My name is Abby Nerlinger, and I'm a pediatric hospitalist at Nemours DuPont Hospital for Children. And today I'm going to talk about barriers to research and data sharing in medical legal partnerships. Some of these issues are specific to MLP, but some can be generalized to broader issues with research in conjunction with community-based organizations. So some of these issues are more broadly applicable. Okay. So just to review, medical legal partnership are partnerships between lawyers and healthcare providers that aim to recognize and address legal and social needs that may be affecting health outcomes. And these are so-called health-harming legal needs and include such things as income and health insurance and access to care, housing and utilities, education and employment, legal status, and personal and family stability. And the perfect example that we tend to use is really housing conditions, things like mold, cockroach, if they're not controlled, can have effect on asthma, and sometimes it can be the landlord's responsibility, and legal intervention can help with ensuring that landlords are complying with housing code policy. So this is the typical process of medical legal partnership, legal need recognition, and then legal intervention. And this is really specific to the medical legal partnership. But as one example, a health-harming legal need is recognized by a healthcare provider. There's some sort of legal needs screening, whether it takes place in a clinic setting, and then this client is referred to the legal partner who does a legal intake and then provides a legal intervention. The legal intervention can consist of what we call 3 different doses of legal intervention. The shortest is a referral to community organization. The next is brief advice on how to deal with the situation. And then the third and most time consuming is extended representation or a full legal case. And then there's a case closing, so sort of an end point for this intervention. And then there's usually follow-up surveys to see if the outcome was sustained. So the context of the problem that I've been looking at is that the data surrounding the effect of legal intervention on health outcomes is not sufficiently convincing for unquestionable healthcare system investment. So whereas many healthcare institutions throughout the country have invested in MLP, it is not completely widespread, including we do not have one yet at Nemours. And so part of the question is how do we strengthen the evidence base surrounding MLP in order to encourage investment, whether that's through the health system, the payer, or even the state. So a little bit about the state of the research and literature. Studies have shown that MLP successfully addresses social determinants of health, but there are limited studies showing that this actually improves health outcomes. And so usually we're talking about 2 different types of health outcomes: patient-centered health outcomes, so things like reduced stress or improved chronic disease self-efficacy, and then health outcomes more of interest to a healthcare system like acute care utilization. Additionally, in the literature, one thing that's come up is that some studies have shown a positive legal outcome, but that doesn't necessarily correlate with improved health outcomes. So these are not always aligned. So for example, if you're able to win a legal case and get a landlord to comply with housing code, that doesn't necessarily mean that the patient or client has an improved health outcome. So it's important to make that connection in studies. And then many of the studies, due to some limitations that I'll talk about, are pre-post, really looking at changes in health outcomes for the same population as opposed to more like a case controlled or an RCT design. So some of the reasons for the lack of robust data. So first, sample size. A system or a researcher can only really collect samples for which you have significant or sufficient resources to provide an intervention. So if you have funding for a pilot to look at the effects of MLP, but only have funding for, say, 20 patients, your power may not be large enough to see an effect, but this could be more significant when scaled to a population level outcome. And then it also depends on the population targeted. You're more likely to see a significant health effect in higher risk populations. So for example, if you have a child with severe asthma that you know is allergic to mold, you're more likely to see an effect by doing housing remediation for mold in that patient than maybe a more mild child with mild asthma. The second issue that comes up is sort of time frame. A full legal case can take 2 years or more, so it can take some time to see the effects of the full legal intervention, which clearly is not ideal to study something like return on investment. The last is data sharing, which I'll get into in the next slide. So what can we do about this? For sample size, we can form MLP collaborations and statewide partnerships. So for example, If you happen to have an adult hospital next door that also has a medical legal partnership, you can try to partner with them to expand the data set. And then for time frame, you can focus on certain types of health harming legal needs. So for example, housing cases usually have a faster turnaround than immigration or special education cases. And you can see a change in health outcomes over a shorter time period. For data sharing, what we can do is streamline data sharing between the healthcare partner and legal partners. And so what does that mean and why is that an issue? I'm going to provide an example of a study that I'm looking at now, finishing up data analysis for the Medical Legal Partnership in Washington, D.C., which is a partnership between Children's National Health System, which is a standalone children's hospital, similar to Nemours, and Children's Law Center. This is the oldest and largest pediatric MLP in the country, so it's conducive to studying because it provides a large data set. What we're looking at in this project, and these are some of the reasons why I'm still looking at this data set so many years after fellowship, but we're trying to complete a case-controlled study examining differences in acute care utilization and ROI for children with asthma referred to MLP services versus those not receiving MLP services. So what data is needed? From the healthcare partner who uses Cerner, which is much more clunky to use than Epic, we need to look at patients who are seen in the asthma follow-up clinic after hospital discharge with a positive screen for health harming legal needs. We need to collect these patient medical record numbers and demographics, and then look at hospital admissions and ED visits. And we're going to do this both through chart review and collection of ICD-10 codes. We're also going to collect cost to charge ratio for acute care visits through the administrative data set. From the legal partner, which is they use a completely geographically separate legal case database because of sort of the arrangement of this being an older medical legal partnership before anyone used electronic health records. We need client name and date of birth, and this actually may be listed under the name of the parent of the child instead of the child themselves, if it was the parent who initiated the referral as opposed to the healthcare provider initiating the referral on behalf of the child. We need the results of the intake questionnaire and legal needs screening, where the lawyer often collects their own independent demographic data, and then documentation of the type of legal intervention provided, in addition to the results of these follow-up surveys, and then cost of legal services if we're going to calculate ROI. So these are sort of why there are these barriers to data sharing. We need to match the patients in the electronic health record to client data. We also need to make sure we're acknowledging lawyer, client, and asthma clinic confidentiality and consent. And in this case, this was a retrospective study, so we actually obtained waiver of consent, but sometimes it's not so straightforward, especially when it comes to very private legal issues. We also were sharing PHI outside of the healthcare institution. So Children's Law Center gained HIPAA compliance. We had to get a business associate agreement signed, ensuring CLC will utilize protected health information in accordance with HIPAA. And then previously we had a data use agreement in place, but the project we're doing required more than just sharing a limited data set. So we were able to obtain the BAA. And you can imagine when you're asking a legal partner to sign a BAA that it takes a while for them to review it. So these models of data sharing different models have been suggested by the National Center for Medical Legal Partnership. They have a great white paper on this, and some of these models can also be compared to data sharing with any community-based organization, not necessarily just MLP. And there's a great paper if you're interested in learning more. But to give examples of the models, the first model, Model 1, is really most autonomous. It's the most difficult for evaluation, the model that most older MLPs take, where the information for the legal team is given to the patient, and it's the patient's responsibility to reach out to the legal partner directly. Any PHI that's shared is passed along by the client themselves and not through any formal data sharing system. The second, Model 2, is MLP staff are located on site and may initiate referral. And then it's the staff who are responsible for obtaining consent to share both PHI with the legal partner, both for purposes of research and program evaluation and actual legal intervention. And then Model 3, the ideal organization is the is the organization that we would implement, hopefully, if we were starting an MLP at Nemours, but this is the most integrated, where the medical and legal partner are part of the same organization. Information is shared using a common format. So there may be a firewall between the PHI and the legal information, so similar to how some of our psychology colleagues may document, but there's a firewall in order to access the chart, that you'd have some protection in place from letting everyone see the legal information, the very sensitive legal information. So the takeaway points from this are thinking in advance about data collection is important for any new academic community partnership. Community partners may need to be covered under a DUA or BAA, depending on what type of size being shared, whether for research purposes or program evaluation. And data collected and outcomes measured depends upon your perspective. So really whether you're coming from the community versus healthcare system and whether these are more patient-centered outcomes versus outcomes of interest to the healthcare system. So this is what I'm exploring with MRDA currently with Lee Pastor as my mentor. And that's it.